2022, Kenya's biggest conversation. It continues. We are saying it's March because April can't have come and the power bills are still high. The promise by the president is that power bills are going to come down by a further 15% by the end of March. So until that happens,
we're still in
March.
Okay.
We cannot move into the second quarter with pending promises.
No.
Tumekataa hiyo. Anyway, we are going to have a conversation now about election preparedness, hashtag Justice Thursdays. And before we introduce the guest who joins us from the Office of the Director of Public Prosecutions, let's remind you today's proverb. And the proverb is from Malawi. Blow your horn in a herd of elephants. Crow in the company of cockerels. Bleat in a flock of goats. If you are in a flock of goats, bleat. In the company of cockerels, crow. If you are in a herd of elephants, blow your horn. Trumpet. Do the appropriate thing with the appropriate audience. Okay?
Yes.
Yeah. If you're with children, get onto the jumping castle.
Indeed.
That's the whole point. Yeah, get onto the jumping castle.
I like that.
Yes. Alois Kemo is a Senior Assistant Director and also the Regional Prosecutions Coordinator for Rift Valley from the Office of the Director of Public Prosecutions. He's with us now in the studio. Good morning, Alois.
Good morning.
It's good to have you on the show. Welcome to the hot seat of the Situation Room.
Thanks for having me.
Don't mind the term hot seat. It'll not be hot. It'll just be very, very, very comfortable for you to sit there and enjoy the experience with us.
Thank you.
So, Regional Prosecutions Coordinator, Rift Valley. What does that mean? That's a long title.
I think I'm in charge of prosecutions in the Rift Valley, the entire Rift Valley, the way you knew it under the previous constitution.
Where? Starting all the way from
Lodwar through to Narok, Kilgoris, but Kajiado is under Nairobi. I think that's the only difference.
Kajiado is under Nairobi.
Kajiado is under the regional coordinator for Nairobi.
And Kajiado here we are talking about going all the way in Kajiado County.
Kajiado County.
Okay.
So from Rongai all the way to Lotoktok.
Okay.
Yeah.
So you deal with now the rest.
The rest.
And these are Narok, Nakuru,
Samburu, Turkana,
Laikipia.
Uasin Gishu, Laikipia, yeah.
Laikipia is also Rift Valley.
Yes.
People forget that. It's on that side. How can it be in the Rift Valley?
Yeah.
Okay, so as a coordinator, as the one who coordinates prosecutions, what does that mean? That means that you're the one who will act as the DPP in Rift Valley.
It means that I represent the DPP in Rift Valley. I supervise all the county heads in that region, and for that matter, all the prosecutors who are in that region. Yeah.
Okay. We're talking about election preparedness.
Yes.
And when you hear the DPP is preparing for elections, you ask yourself, why is the DPP preparing for elections? We know the judiciary is preparing for elections. We've spoken to the chair of the Judiciary Committee on Election Preparedness, Justice Mohammed Ibrahim, and he's told us it's because, obviously, you're going to have very many petitions that are going to come to court. And we have also heard from the security. They have to prepare because they are providing security during elections. Why is the DPP preparing for elections?
So you are all aware that during elections, Kenya has had a lot of problems. Violence escalates during elections. There are a wide range of offenses that are committed during the election cycle, even though they could just be ordinary offenses. But you find that there could be an upsurge. Political violence, sexual and gender-based cases, they rise. There's fraud even in the electoral process. And all these things necessitate that all the agencies that are involved in the enforcement of the law take action so that we assure Kenyans, as the Constitution stipulates, that there's going to be a fair and just election. it's all about people choosing the leaders they want, determining, because that has a bearing on the life they're going to lead. And so it is important that an environment is provided where they can choose the leaders they want in a fair, devoid of any violence, devoid of undue influence, or any such offenses that could be committed.
Historically, what have been some of the cases that you have seen as pertains to elections that you would then keep on your radar and say, okay, these are some of the things that we're likely to see or that we would watch out for?
So I think the most worrying thing we've noted in all the previous elections is sometimes the violence, because that really threatens the national security. And I think the strategy the government uses is that you have to nip that in the bud. If there is any wave of violence, or you see some tendency taking you towards that direction, the strategy is just to take action against the people responsible, so that they serve as a lesson and deter other people who would be thinking similarly.
Okay. And would you say that some of the cases that then were brought to you, I mean, because after investigations have been done, you say, well, we have adequate evidence or information to say, look, this now needs to go for prosecution. Those which have come to your table, would you say that you have seen then justice served, or that you've been able to take cases from end to end, or have they unfortunately sometimes ended up in smoke?
Of course, the environment or the circumstances in which some of these offenses are created poses a challenge. We have offenses that are committed in public rallies. Ideally, we're supposed to have monitors monitoring some of those rallies. We expect that perhaps the persons who are monitoring, who are investigators actually, they could be from NCIC, they could be police themselves, that they would be able to record the events, and in the event of, say, for example, hate speech being committed, that such utterances could be captured, and that therefore the evidence could be availed to the prosecution to use against such people. We also have your colleagues in the media who sometimes record, but sometimes the challenge is, particularly from the media, it is very difficult for a person recording on the ground to come forward and offer to testify. So there are those challenges, and the government cannot be everywhere at the same time. Even though it is said serikali na mkono mrefu, but the reality is the police cannot be everywhere at any given time. So analyzing the cases that we've had previously, we noticed there were some gaps, and that necessitated that there be a paradigm shift, so that the approach to investigations and prosecution of these cases be different. So learning from the cases that we've had before, we decided to come up with this compendium, which is basically just instructions to prosecutors on how to handle some of these cases when they come before them. So we are drawing from all the policies that we have in the Office of the Director of Public Prosecutions, and giving instructions, basically, if it is pre-trial, say in the investigation stage, what is it that a prosecutor can do? The ODPP Act permits prosecutor-guided investigations. So you can guide an investigator on the kind of evidence, the lines of inquiry they need to follow. You can tell them on the admissibility of evidence. You can talk about the relevance of that evidence. You can advise them on the credibility, in other words, the believability of that evidence. And a varied range of parameters that would become important once you start prosecuting a case.
Would this mean that you lower thresholds? So you've got the decision to charge
Yes.
protocols, which say this is how we're going to determine if we're going to accept to go to court with a particular case. Now, you're saying that you're looking at all these things and reviewing. Would it mean lowering some of the thresholds?
We are not lowering the thresholds. I think in the field of law, in the criminal law practice, the prosecutor has a very high burden because the standard is you must prove beyond any reasonable doubt. Any iota of doubt in your case is always resolved in favor of the accused person. So that is a very huge burden. But as prosecutors, and under the decision to charge guidelines, I think we look at the evidence because the decision to charge guidelines sets the standard, and it should be that a prosecutor looks at the evidence, determines whether it is sufficient. What we refer to as this two-stage test in the first instance. Look at the sufficiency of evidence and look at all those parameters that I've discussed: the admissibility of evidence, the relevance. Is that evidence going to be available? If it is electronic evidence, is that issues of chains of custody? Then, after you are satisfied that there is sufficient evidence, you then go into the second test, which is the public interest test. And what the public interest test really is, it's not public pressure as most people would perceive it. It is what is in the wider interest of justice or the wider interest of the community.
Yeah.
So after you have satisfied yourself there is sufficient evidence, you could, for example, look at what harm is this going to cause the community. Is this a person that it would be in the ends of justice to prosecute? For example, you are faced maybe with an accused who is 98 years old, and you want to take that person through the rigors of trial. I mean, that is what public interest really entails. What is in the wider interest of justice?
You know, I'm asking this because we have had by-elections in the last 4 years, and we've had incidences of violence in by-elections. We're talking about just elections in this particular case. Kabichai Matungu by-election, widely publicized, everybody saw what was happening. There was violence, right? And yet, in the instances where people have been taken to court, someone goes to court and say, no, I was not slapping the guy, I was just saying hi. And cases don't move. We have not seen proper prosecution as a result of what happened in Kabichai. An electoral official was sexually assaulted. Well, in our opinion, not, you may tell us maybe it's not the case. We saw somebody being roughed up in the glare of cameras, and yet no prosecution is actually going. How can we trust that you are going to be able to prosecute if we have widespread cases on August 9th?
Okay, I may not have interacted with the file in respect of that Kabuchai incident, but I can speak widely from my experience as a prosecutor, that, you know, a file could be presented to you for review, and you apply all the policies in determining whether there is a case or not, whether there is sufficient evidence. You run those tests that I've talked about, and you make the decision to charge. But the story, when you go to court, changes because witnesses grow cold feet. We are aware of instances where witnesses have been threatened. They disappear. Some are influenced not to come and testify. So there are a variety of reasons why sometimes cases fail to take off. And this compendium, one of the things it speaks to is to guide prosecutors that at a very early stage, try and determine whether there are any vulnerable witnesses and whether there are steps that you can take to protect them, and in that case, so that you can protect the evidence when the case comes up for trial. And we then liaise with the Witness Protection Agency, have those witnesses placed under protection, because the Witness Protection Agency they have their own ways of assessing the level of threats and what protective measures they can put in place to protect.
But Alois, let me just pause you.
Yeah.
You know, you're currently heading the team from the ODPP that is looking at how best to handle incidences that may require the ODPP to act. What lessons are you drawing from those by-elections? From the by-elections that we have, for example, those Kabuchai ones, where clearly we have not seen justice.
And this is the reason why I'm saying. I said I may not talk about the Kabuchai case because I've not interacted with that file. But generally, we have observed that witnesses sometimes, when you take a case to court, witnesses grow cold feet. You summon witnesses, they fail to attend. Sometimes you don't know. You could be told that they relocated from their places of residence.
Or they've been threatened.
Or they've been threatened.
Yep.
Or they've been paid not to come to court. There are wide variety of reasons. So the lesson we learned is that it is necessary to identify a witness who could be vulnerable. And that can be determined from the kind of testimony they are giving. Perhaps they are giving testimony against a very impressionable person in the society. And you could then determine that this is a person perhaps we need to put in protection to secure their evidence or to get them away from people who could try and influence them.
I see a second challenge, though.
Yeah.
And the second challenge here is that when you talk about a witness going into witness protection, you're talking about disrupting their daily life. What would you use to convince this person that, okay, yeah, you witnessed this and you saw it happen, and we'd like you now to become our witness. So we're going to put you in the witness protection. We have to then move you from here probably. And, I don't know what it would entail. But you're basically telling them, sacrifice your life so that so-and-so can get justice.
So what the Witness Protection Agency does is they do their own assessment. And they carry out interviews with the people responsible. And I think they determine what are the best measures that they can put in place. Sometimes somebody can be relocated, taken to a location that maybe nobody knows. It could sometimes result in change of identity. There are a wide range of measures that they can take. If the level of threat is low, we could even just have this person brought to court under camouflage. Maybe he wears a kanzu, goggles, and a hat just to conceal their identity. But it all depends on the level of threat that a witness faces. We have seen.
With the number of cases that have then been brought to you, what would you say that on the majority, if you're able to do a split, what would you say that then you're able to see some of these cases through, or some of them have ended up whereby, somebody who would have then been protected by the law, unfortunately, we have these cases whereby somebody has been paid, somebody has been scared, somebody has been intimidated, whatever the case may be. Which ones would you say tip the scale? Those which have been closed, unfortunately, or those then that you've seen justice see?
I think without necessarily giving the statistics, but my observation is that they are half-half. There are cases we have successfully prosecuted. There are cases where we have challenges. I've just spoken about, with the proliferation of technology, the platforms on which offenses could be committed are now so varied. You could have a statement maybe going viral, or somebody making some utterances that are offensive going viral.
Yes.
There is a very big challenge. It could be on a social media platform, Facebook, for example. It could be on Twitter, on those platforms. And that kind of evidence, you all know that the challenges we face sometimes is not being able to prove whether that clip is original or it has been edited.
Yes.
So that challenge is there, and courts have really insisted that we need to authenticate, demonstrate that is the clip that was taken.
And even beyond that,
Yeah.
we've also heard a lot of explanation has been given. Eric alluded to one of those examples that something could have happened, and then somebody says, well, you know that it wasn't my intent. My intent was not to cause any harm. When I was saying this, I wasn't really, I was just, in the throes of the moment, perhaps saying so. Intent has been one of the most difficult things to prove or disprove. And in terms of prosecutions the world over, how do you deal with some of those things? Because we've seen a lot of times they say it was not my intent, and then it kind of ends up in smoke. How do you deal with that?
So one other thing we have done is we have looked at the international best practice. You are aware that under Article 2 of the Constitution, those international conventions form part of the law of the land.
Yes.
And then treaties that we have also ratified also form part of our law. And going by that principle, we have the Rabat threshold test. It arose from Rabat Plan of Action, and what they were trying to deal with, the world community generally. It was under the auspices of the United Nations. The threat of hate speech and the harm it causes. And so they came up with a 6-part test that one would use to determine whether you could take action against perpetrators of hate speech. And the guidance they give is that, first of all, if you're talking about those utterances, what is the social, what was the social or political context in which they were made? Then you look at the status of the person who's making those utterances. Is it just a simple person? Is it an influential person who could influence other people? They talk about the intention, what you're speaking about, of the speaker, the content of the speech itself, what was uttered. Because if you're going to charge somebody, for example, you're supposed to put the exact utterances in the language in which they were made, and maybe a transcription and a translation also made for the benefit of whoever is going to prosecute or be arbitrating the case. And then you look at the extent of dissemination. How far has it been disseminated? You look, for example, what is the platform that is being used to disseminate that kind of utterance, and the likelihood of harm that is likely to be caused. So these guidelines, or this test, this threshold, Rabat threshold test, is not meant to replace or substitute the decision to charge, but it complements the decision to charge. And I think this is a new innovation. I think for the first time, we are going to apply these principles in determining.
How many steps were they? Were they six?
Six parts, yeah.
All those 6, Alois, as I heard you talking about them, I thought about Eldoret, February 2022. Was it February or was it January? Mithika Linturi speaking in Eldoret. Public, widely publicized. Mithika Linturi is a senator. The context of using the word madoa-doa, all those things. And I'm just ticking as you go. I mean, I'm just... And then I remember that the ODPP went to court and said, you know what, we can't sustain this case. Let's withdraw the case. You are the man in charge of Rift Valley region. Eldoret is in Rift Valley now.
So this case is still actively under inquiry. And I wouldn't want to comment, but I think we were guided by the decision to charge guidelines in arriving at that decision. Yes, the context in which the utterances were made is there, but there was still a challenge somewhere with that kind of evidence. And I think let me just leave it, because it is a case that is actively under investigation, so that I don't jeopardize the efforts that are
being made by the investigators.
By the investigators, yes.
Okay, let's take a break. 28 minutes to 10, Kenya's biggest conversation. Alois Kemo is a Senior Assistant Director of Prosecutions, also the Regional Prosecutions Coordinator for Rift Valley in the Office of the Director of Public Prosecutions. We are talking about what the ODPP is doing to prepare for any likely upsurge of cases that they may need to take to court in this electioneering period. Hate speech, violence, also violence. Last weekend, helicopter stoned. That is violence. So all those things, what are they doing to prepare themselves to adequately deal with these cases and take them to court and to get justice?
This is the Situation Room.
This hour, Alois Kemo, he's the Regional Prosecutions Coordinator for Rift Valley in the Office of the Director of Public Prosecutions. We're talking about election preparedness and what the ODPP is doing to prepare itself in the event of an upsurge of cases that they may need to take to court. And we're already seeing that, Alois. This year alone, so we've had that incident in Eldoret with the mythical Inturi. You're saying investigation still ongoing. We have the weekend incident on Saturday with the Raila Odinga's helicopter. Investigations are ongoing. But as they are going on, the conversation is already being primed in public domain, just the same way with the mythical Inturi conversation. It was primed in the public domain. This word, madoa-doa, is a daft word, is a bad word, context of where it's been used and all. This one for Raila Odinga. Yesterday, the CS for Interior and Coordination of National Government appeared before parliamentarians and he said this thing had been organized. Somebody had even had money and they were paying people to have, and that's the evidence that we have. Everybody then expects that the day Kemo goes to court to charge whoever Kemo will be charging, Kemo will be showing us who had the money and who paid these people to stone Raila's helicopter. You're already being placed in an awkward position here, aren't you?
Until the file is submitted and we see what evidence is in the file, I'm not in an awkward position. I'm a trained lawyer. I'm a prosecutor of many years' experience. I know what to do with a file when it is placed before me. And it's not going to be different. We are going to analyze the evidence that will be submitted. Whatever the minister said, he said, perhaps as a person who is in charge of the security of the country, maybe he's privy to information that we still are yet to have. I last spoke to my counterpart, the regional police commander, about this issue, and told them that it was necessary that they forward the file to us well in advance so that we can review it and make a decision. And at the time we spoke, we agreed also that an application, because they requested for more time to pursue some of the leads they needed to pursue after they interrogated some of the politicians whom they summoned last weekend. I think it is just fair that the investigators carry out their investigations. I'm hopeful that those lines they gave were credible and that something will come out of it. That because that action definitely is abhorrent. It is something that we cannot entertain against anybody, not only the former Prime Minister.
In as much as we know, I mean, that there are definitely cases which you prosecute which are away from the public eye. There are many, there are quite significant ones that have been right there in public. And it would appear as though public outcry then is what feeds into action from your office. There are some cases whereby everybody's made so much noise about it and then we've seen action thereafter. Does the level or magnitude pressure of public outcry then have an effect on what you will choose to then go after in terms of case, especially one as sensitive that has anything to do with the election?
So one of the things that this compendium speaks about is it discusses prosecutorial independence. And I remember yesterday I was speaking to the prosecutors who are in the training that is currently ongoing since Monday, just sensitizing them on this compendium. And we were discussing, and I told them about prosecutorial independence. Don't be swayed by any other thing other than the evidence that has been brought before you, the law, and nothing else. That is what should guide you when a file is placed before you.
Yeah.
And to the best of my memory, I think that is what guides us. If the Linturi case was anything to go by, there was a lot of pressure. But we still stood to say that we need to have the evidence that would warrant us taking this case to court. Because there has to be a reasonable prospect that a court properly directing itself to the law and the evidence would convict a person. If you are not satisfied, then that case is not ready. And I think in other jurisdictions, people take time to investigate. I wish we could do that here also.
Apply ourselves to investigation.
Yes.
And with
Because
time.
that, yeah.
You know, Elias, as you're saying all this, in other cases where you have to, where you have to deal with criminal prosecutions, you mostly will deal with the law. But when it comes to campaigns and elections, you're not just dealing with the law, you're also dealing with politics. And there's public perception. And then there's also pressure. Now, how does that come to bear on your work when you're dealing with this? Because yes, you will tell me, I did not get sufficient evidence to take this matter to court, or the evidence that was adduced before personality A was not sufficient for me to actually go and prosecute this person, but I had sufficient evidence against so-and-so who was caught with a stone, and they're the ones who threw the stone. But the person who had paid them to go and throw the stone, whereas it could be public knowledge who that person was, but you don't have sufficient evidence. But then you see the problem that brings to your office is the perception that you are only going after the small fish, the chicken thief, while you know very well the person who organized this is so-and-so and you're going for them.
Eric, I repeat again, that when a file is brought to me, I analyze the evidence, and I analyze the evidence against each individual suspected to have committed the offense. And I must satisfy myself that there's sufficient evidence and determine what charges to bring against that individual. That is what guides me, that is what guides my colleagues in making that decision, whether or not to charge. Nothing else comes to bear, no amount of pressure. Yeah, because we are only guided by the law, we are guided by the Constitution, and we are guided by the policies.
But it also sounds like you're also guided by the investigator. Because if you don't have sufficient evidence, so if the investigator has not brought you sufficient evidence, despite you as a lawyer knowing very well that this Ndu is guilty or Ndu is a perpetrator, Ndu needs to be before court. If Eric, the investigator, has not brought you sufficient evidence to prosecute Ndu, you're like,
there's nothing I can do.
I mean, I've got Rabat, I've got...
Those are the standards. I mean, prosecutors are ministers of justice. As in, there are people who are supposed to preach justice. A prosecutor is not supposed to seek conviction by all means. So I'm not going to take someone to court when I don't have evidence. It is not the right thing to do. Yeah? It is not the right thing to do. You must have. And remember, a person is presumed innocent until he's proven guilty. Remember also that if we adopted, say what you're saying, because I'm not imagining you're telling me to take somebody to court without evidence.
No.
Because, Eric, you might walk out of this building and somebody just arrests you, yeah, and takes you to court. Is that what Kenyans would like?
No.
No. Everybody wants to be assured that if there's a case against them, there will be evidence that will have been tested by the agencies that are involved before they are taken to court. And they're given their day in court so that the evidence is adduced against them. They're given all their constitutional guarantees to defend themselves. I think that is the only way that someone can achieve
But don't
justice.
you have another obligation to the victim? Let's think, if there was another round of post-election violence and people have been killed, okay? don't you, as an office, have an obligation to the victims of that violence? So say that you shall do everything humanly possible to dig deep, working with the investigative agencies to find out the culprits, to have sufficient evidence that can then be taken to court to prosecute the perpetrators and have justice.
You know, on Monday, when the DPP made his remarks at the opening of that training, in the presence of the Chief Justice, and all these principles of these agencies, law enforcement agencies, were in attendance, he gave a commitment that they will ensure that where there are offenses committed during this election cycle, he's going to take action. But that action will depend, obviously, on the evidence. Eric, I want to say that we all have a responsibility. To the young people, I would advise, don't be swayed by the utterances that are made. Don't commit those offenses. And I think going forward, we are going to have engagements. This is one such engagement that we can have. I hope the people listening are enlightened, but we are going to have more of such engagements so that we sensitize the public also on the law and what could follow if they violate the law during these elections.
Sure. And how would you say that you are prepared for going into the elections? Because, I mean, if anything that we've seen in the last few months is something to go by, and, you know, what is out there in matters of public opinion, that if we've already started on this path, that things are likely to get sticky as we draw nearer and nearer to the election. So how would you say that you're prepared to now be able to deal with any of these things that then might creep up?
So what the DPP has done is to appoint focal point prosecutors throughout the country. And we are having at least 2 or 3 prosecutors within every county that are then going to handle these cases. We expect that he has also created the Hate Speech and Electoral Justice Division within the office, headed by a Senior Assistant Director of Public Prosecutions. And it will act as the secretariat. Whenever a case is filed, even if it is filed in Lamu or Kehancha or wherever, it is our expectation that they will relay that data and what has happened in that particular case on a daily basis, so that we are able to track those cases. And the regional heads will, as I've stated, be the representatives of the DPP to make sure that everything is done properly. The other thing, as we near the elections, we are going to do is that we are going to create some sort of 24-hour call center where we can also receive complaints. You are aware the DPP, under the Constitution, is mandated to direct the Inspector General or any other investigative agency to conduct investigations. So when we receive a complaint, we will be able to determine which is the relevant agency, and the compendium spells out all those agencies and what their respective mandates are. IPOA, holds the police to account. If it is any offense related to corruption, we can refer the case to and all those other agencies. So that command center, which will be, as we near the elections, will be a 24-hour call center, will be manned by prosecutors throughout the day, and will also be receiving reports from the counties and the regions on what is going on. So that generally provides the oversight mechanism that the DPP is going to have whenever an offense is committed.
There are cases where the DCI has actually felt as if the DPP is a stumbling block towards justice, in that DPP has spent sleepless nights investigating a particular case,
DCIS
rather, brings the file to the DPP, and then the DPP says, "Oh, Rabat, threshold not enough. I'm not going to court."
You know, I would tell you that when I started prosecution more than 25 years ago, we never had any guidelines. Yeah, so that if I made a decision, you would not know what I considered in arriving at that decision.
Okay.
Yeah, under the current dispensation, we have policies and guidelines, and we have sensitized all our key stakeholders, yeah, including the National Police, EACC, IPOA, all the investigative agencies, including Wanjiku herself or himself, on those policies. And today, Eric, if I were to make a decision, you can actually, based on those guidelines, be able to determine how a decision was arrived at. And that is all I can say about that. So, if at all,
so what do you think needs to happen? Is it more sensitization of the DCI for them to understand the DPP?
Perhaps that is one of the things, but remember, whenever a decision is made on a file, it is returned with reasons. Yeah? If it is insufficient evidence, the DPP could be telling you, cover this aspect of this case and resubmit the file. Or clarify this and resubmit the file. A prosecutor is the person who knows. Because a prosecutor is supposed to anticipate even what the defense could come up with during the trial. And so we work ahead to see if we can plug some of those gaps. And if that is what the DPP is doing, he's only doing it in the interest of justice, to strengthen the case so that when it goes to court, and there are so many cases that have gone to court and succeeded. We have seen EACC, they submit their files. All these other agencies, they submit their files, including the police, Mr. Latif. So I think maybe those are just isolated cases.
In very many cases, though, do you actually consider the capacity of the investigative agency and the officers in the various stations? So, for instance, you may need a lot more, but you very well know that this particular station and the officers here do not have the capacity to give me what I need.
So there are instances where, because when a file is submitted, you can obviously see the rank of an investigation officer. There are instances throughout my career that I've seen a file and said, no, they didn't give it their best shot. Perhaps because of their level of experience, they were not able to cover. And I've recommended, could this be given to a more senior officer to see if they can do a more professional work. But you see, that is something that you could have noticed, because reading a file, you can tell that they didn't apply their expertise in unraveling the truth about that case. But overall, I would say that is a matter that would best leave to the National Police Service. They receive the complaints, they look at the complexity of the case, and then they are able to determine who they are able to allocate that case so that it is competently investigated.
Okay. Yeah. We want to thank you very much, Alois, for coming to join us today. Alois Kemo is the man in charge of criminal prosecutions in Rift Valley, all the way from Lodwar, like you said, bordering Ethiopia and South Sudan, bordering Uganda, coming all the way bordering Tanzania, down paka hapa Nakuru, hapa Naivasha, hapa Mai Mahiu, all the way.
Bado ni Kenya.
Bado ni Kenya.
Yeah.
Thank you very much for joining us.
Thanks for having me.
All the best as you and your colleagues work on dealing with cases of election malpractice, election violence, and all.
Help us sensitize the public also.
Yes.
And it's really my pleasure having met both of you. Say hi to Muga. I don't know where he went today.
He's on leave. Man is enjoying his time.
Oh, you also go on leave.
Yes.
Imagine.
He goes on leave.